L'état nous cause pandémie COVID-19, nous souvent basés sur l'aspect de la santé publique ou bien sur l'aspect économique. Mais il y a l'autre sujet qui monte pendant les derniers temps, qui beaucoup de monde peut cause là, c'est qui la pandémie COVID-19 il affecte les droits du monde pour gagner accès avec la justice, ou bien qui la technologie devrait plus grand servir en cours, qui fait que les monde pas besoin de venir physiquement en cours, soit pour donner l'évidence ou bien pour écouter d'autres cas. À l'occasion de la journée Constitution, Zidisyer alors organise un débat l'ossasisé. On nous suit.
Our time calls for draconian legal measures dictated by the COVID-19 pandemic, all in the interest of public health, in the national interest of the public at large. We have promulgated many laws, many regulations restricting the movements of individuals, setting standard operating procedures. We have started the practice of virtual hearings, and all those have somewhat impeded, if not limited, the exercise of our constitutional rights. It may have been done through a law, justifiably necessary in a democratic state. It was not done, or they were not done, through derogations of right, which could have been done under Article 43 of the Constitution, as it has been done in many other areas of the world as emergency measures. However, we note that even here, even if it was to be done through an emergency law, the rights that we are going to talk about today, which is Article 19-226, could not have been curtailed, because Article 3 make it clear that any law that can be curtailed during an emergency state does not include the right to fair hearing, which are listed in Article 19-226. So the right to fair hearing in this jurisdiction is almost absolute. We are therefore here to see what we have done and what we are doing as a jurisdiction to ensure that this absolute right is maintained at all costs and that we are not complacent to it. To take a straightforward example, right to a legal counsel. The actual standard operating procedure means that the client is at the remand center or at the prison. Counsel is at the court in the virtual hearing room with the judges and the other court staff. Counsel has no physical contact with his client. Most of the time, or occasionally, he's just been arrested and he needs to speak to his counsel. Sometimes it looks as if there is a problem with instructions. One is saying one, the other is saying the other. But all the communication is being done virtually at the hearing of all parties. The constraint of our time, the practicalities of our time, given the COVID-19 standard operating procedure, means that we have to do it. But is this fair? Is there any other ways of doing it? How do we ensure that the rights which this individual on the other side of the line or the camera may not even know its scope, its extent, is preserved? So we are here. I invite you to a frank, straightforward discussion, because at the end of the day, what we want to do is we want to walk away from this room feeling as if we have explored all angles of this very practical but important questions.
I would like to introduce our panelists. We'll start obviously with the Chief Justice, very well-known figure in Seychelles' legal sphere. He's not only our Chief Justice, but also a judge of the Supreme Court, sitting on both criminal and civil cases. Justice Anthony Fernando, President of the Court of Appeal, first appointed in 2009. He's also a visiting Justice of Appeal on the Court of Appeal in Fiji since 2015. Justice Renaud, retired judge of the Supreme Court and Justice of Court of Appeal. He also served as ombudsman for 10 years. He was the chairman of the Constitutional Commission, which produced our present-day constitution, so it is apt that he is here. He has managed 4 elections and referendums connected with this. Presently, he is serving as chairman of the Human Rights Commission, as well as the Commissioner of Public Persons Declaration of Assets Commission. Stephen Powles works at the AG's chambers as a state counsel. He's a UK qualified barrister specializing in international crime and extradition. Mr. Raymond Saint-Ange was appointed as superintendent of prisons in 2017, but he's also a law enforcement specialist who served in the US Navy for 10 years. Kelly Louise is head of Civil and Commercial Division of Georges & Co. Attorneys, where she has been for the last 5 years and in that time has been involved in both local and international commercial arbitrations. Divino Sabino is the president of the Bar Association. He's a former state counsel at the Attorney General Chambers and part-time lecturer at the University of Seychelles. And finally, but no least, Edith Wong is a private practice lawyer, having been called to the Bar of Seychelles in January 2017. Panelists, thank you for being here. I will now hand over to our moderator, Sylvia Kamanja, to lead the discussion.
So the question really is, with this global shift towards virtual hearings, which has been forced upon us by the pandemic, with some countries actually now making long-term decisions and looking into having this as an ongoing thing, not a short-term emergency measure for COVID. Of course, we don't know how long COVID will be with us. We will be discussing the right to a fair and public hearing, as the Chief Justice highlighted. There are some fundamental problems in that area, and so that will be the first question that we discuss. And I'm going to open the floor for each speaker to just highlight what their initial thoughts are on virtual hearings, what issues they've encountered personally so far in this area.
Definitely on the side of the prison service, our one aim and goal is to deliver the person to the court. How that is done basically through the communications we've had to date. Like the Chief Justice said, we are using a virtual system, and where we cannot protocols to approach the court. It's interesting that Article 19 meets COVID-19, and I think we're all in this together to make sure that Article 19 prevails, and that in no way detracts from the ability for the person to have a fair hearing and trial. Technology definitely is going to play its part, as it has, and I think we can get through this, but it will take a community to do this, to make sure that on the prison side that we continue to deliver that suspect so he or she can have a fair hearing, whether it's technology, safety protocols, and understanding COVID-19 and the pandemic.
Having experienced both a hearing virtually and an appeal virtually, the main points that come to front is that you have difficulty communicating with your client on the day of the hearing, which is something that you can normally do during a case where they are physically present. I would think that perhaps right now a virtual hearing in the Court of Appeal is a much more feasible matter and appears to affect Article 19 the least, except for the fact that given the way that the room is, it does affect the right to have the hearing in public. And so that is something that is an issue that I've encountered on each time that I've had a virtual hearing. In terms of other issues that we've experienced at the bar, it becomes COVID-19, not just because of the fact that they're virtual, but the fact that there have been decrease in the amount of cases that can come forward has provided delays, which is also affecting the person's right to fair hearing to have their case heard in the quickest amount of time possible. So I think it does require lots of planning, and Seychelles needs to upgrade its infrastructure if we were to look at this in terms of a long-term idea.
I've discovered that this business of COVID seems to be a permanent structure now. Number two, that our structure of the court was not fitted and is not fitted for this challenge. Three, we have to change the whole thing. it will cost or whatever, but a lot of brains will have to be brought in for us to reorganize ourselves. I'm viewing the judicial system from the outside now. When you're inside, what you do, you change your procedures, rules, amend this, and put a practice direction or whatever. But when you know the inside and you go from the outside and look at it, as the chairman of the Human Rights Commission, I'm taking this up, and we have started conversation with the President of the Court of Appeal, with the Chief Justice. We know that the process is a process that will take some time, and in fact with other institutions of state. But we have to do it professionally, systematically, orderly, and we don't shake everything, but we move it, we change it, we change it. I'll give you an example of access to justice, which when I was inside, I did not realize that. I've taken the opportunity to stand in and be a guy from Ladig who is a witness in a criminal case in court. The Supreme Court, we know, is at the Iljipo. It's not in Victoria, it's on an island somewhere in Seychelles. I have to be there. I have to be there at 9 o'clock. I've received a summon. I live at Nideg. Nideg is part of Seychelles. I have to be here. What do? I am employed. If I am absent, my day will be cut. Otherwise, I have to take a day off. But is a day off enough for me? No. I have to take 3 days. Come a day before, sleep over, attend court, go back tomorrow. If I live at Montfleury, I'm also a witness. For example, my colleague will come from Montfleury as a witness. He can even walk here. Let me tell you what happened to me for me to be here at 9 o'clock. I booked a taxi the night before to come and pick me up at home to take me to the Ladig port. I paid him 100 rupees to come and fetch me, and when I return, he will take me home because it will be late. I have to pay him another 100 rupees. That's only 200 rupees. And then I need to get a boat from Ladig to come to Prale. And I have to book it and organize. I pay 70 rupees to get a boat to Prale, and I pay another 70 rupees for me to get a ticket when I return. And then reaching Baie Sainte-Anne, I take a taxi, and it is, you won't believe it, 500 rupees from Baie Sainte-Anne jetty to the airport. I checked the facts. All these are facts. So I pay 500 rupees, and when I return, I have to pay another 500. And then I take the plane to Mahe. The plane will cost me 700 rupees, depending on the time, because I will come at 8. So I will pay 700 rupees. Return, 700 rupees. That's 1,400 rupees. At the airport, I will take a taxi to come to Iljipo. I've checked it, verified. It will be more than 600 normally, early in the morning, but I put it 600 rupees. That's 1,200 rupees. I'm in court now, there, in the parking. And then I put lunch. This is something else. You know how much it has cost me up to the outside the gate there? 4,000 rupees. I drop at the gate. I am from Ladig. I don't know anything here. I saw 2 gates. Now which one to come to court? I sat there, look at both gates. I took the first one. I walk around, there are 2 buildings. All doors are closed. I don't know where to go. But a good gentleman told me, go to the other building, Supreme Court is there. So I went to the other building. I looked for the door to come in, I could not find. Everywhere is unclosed. I looked everywhere. It's true. I mean, it happened. So I walk around going towards the other side of the building. I did not see anybody. I saw somebody in uniform standing somewhere there. I walked there. I asked him, say, I'm a witness. I've come for a witness in court. Where do I go? Say, you go there. But say, it's closed. So it's not closed. You go on this door on the left. There's work in. You knock and go there. I came back. Yes, I saw the letters. I could spell at least I walk in there. And then, yes, there were the formality, COVID formalities, and then what next? I was in a big lobby of a court. Where to go? Fortunately, I could see somebody standing behind the counter and inquire. Yeah, yes, you walk up there, court number 8. See what happened then? He will call you. Or what I'm telling you are facts. I walk up the stairs. I sat by court number 8 on a bench. I wait for me to be called. I sat at 9 o'clock, 9:30, 10 o'clock, 10:30. I come from Ladig, no breakfast, no nothing. I don't know the place here where I can get some food. Waited, people with long robes and jackets and up and down, in and out. I'm sitting, court number 8, I come from Ladig. All of a sudden, movement stops. People started going, I'm sitting. Come 10:30, 11 o'clock, it's lunchtime, I don't do anything. All have gone, people have gone, I'm there alone, sitting at number 8. So I walk down, come to the counter, and I say, but I've been waiting, my name has not been called. But no, but maybe something has happened. In that case, what to do? I don't know what to do. I have to go back home then to Ladig, and then, for example, I go back home to Ladig. The problem I had is that I was informed that you failed to attend court. I was in problem. And then now, how much money I'm going to get in return for my service as a witness of the Crown, of the state, to assist in the access to justice. Ladies and gentlemen, we're getting my 17 rupees for this. Thank you very much. That is access to justice today. The thing is, what I'm making the point is, that thing has been going on for so many years. COVID has stricken now. We must stand up and reorganize ourselves to put us in line with the not COVID situation, but use COVID to reorganize our system. Because as a human rights person, I say access to justice must be equal, equitable to all citizens. My being a witness in Ladig cannot put me lower economically than my colleague who lives at English River. Let us take this opportunity to relook at the system, because the Human Rights Commission is looking at the system from the outside. And in all instances, now I'm telling you, it's not judiciary only. Almost all institutions of state that we are working with, citizens are saying there's a problem somewhere. COVID has alerted us for us to organize ourselves.
Justice Rendo made a very pertinent point. The combination of access to justice and right to fair hearing virtually. Our law, as it is now, gives, I think, too much emphasis, places too much emphasis on live evidence, viva voce evidence. Obviously, because it predates technologies. If you look at our Evidence Act, all the case law that is based on the Evidence Act and the settled practice of our court goes back many years when the advent of even TV, virtual technologies in the sense of electronic systems, smartphones, computers were absent. And how do you get witnesses? Witnesses had to be obtained to someone, and they had to come physically in court. And it is there that the evidence is tested. But I think things have moved on, and COVID has shown this to us. Things have moved on. You can have witnesses testifying as if that person is there sitting in front of you, provided the system is up and running. So I don't think we should be fearing of virtual hearing. But what we need to ensure is that in so doing, that the environment is right, that there's no tampering with the witnesses, there's no tampering with the technologies, that there's safety and security in the system, so that when this person testifies, it is as if he was in a courtroom, and all the other safeguards in the right to fair hearing is observed, in the sense that counsel is there. If he is an accused, his counsel is readily available to protect his rights. If he's a witness, he is duly cross-examined in accordance to law. So what needs to be done is basically we build the system, make it safe, secured, and then have the proper rules and regulations that has to fit and be in conformity with the constitution of democracies. Once this is done, then it will be optional to the court to decide if that case calls for hearings to be done virtually, given the circumstances pointed by Justice Reno of a person coming from Ladig to Mahe and spending 4,000 rupees just for him to stand in a witness box for 5 minutes and testify as a witness for the prosecution. It doesn't make any sense anymore. So, again, COVID is also opening our eyes for other occasions so that we ensure that nobody is made to suffer unduly because he wants to be a part of the justice system or he needs to be involved in the justice system process.
Of course, what the Chief Justice said was in respect of trials before the original court or the trial court. This issue does not arise that much before the Court of Appeal because there is no witness testimony. Everything is on file. All the testimonies are there. The only problem that I see, which of course we should be able to get over with the advancement of technology, is where a judge has to determine the demeanor of a witness. Because that's where sometimes you make a judgment as to whether a witness is speaking the truth or he's speaking false. Now, I do not know, as technology presently exists in this country, of course, whether you see with the hiccups and the shortcomings, whether a lawyer cross-examining a witness could be able, within that time period, to get out from a witness and for the court to determine whether he is giving truthful evidence or not. But I suppose, as both Justice Reno and the Chief Justice said, we have to advance in our technology to ensure that there is no tampering with witnesses, as the Chief Justice said, and also there's a clear view of when the witness is testifying.
If I may, I would like to take up what the Chief Justice and Justice Fernando just touched upon, which is the possibility to properly examine a witness and observe their demeanor while they're deponing. I think there's one point that Mr. George and I discussed this morning that maybe is a bit more difficult to pin down, and that is during criminal proceedings, the right of the accused to face their accuser in person. That is, to our mind at least, a fundamental part of Article 19, the ability to stand before someone accusing you and have them repeat what they're saying in front of you so that we know that it's real, that it's cogent. I think that's the only point really that we can see where we might have difficulties or challenges when implementing virtual hearings as a normal course of practice for criminal hearings specifically.
Just to keep you informed that before the COVID-19, all hearings, the judges were here. Now, you would appreciate that in the Seychelles, we have one of the judges who are non-resident. And even before that, there were several non-resident judges, but they were all here for the Court of Appeal session. Now, in April 2020, with the COVID-19 suddenly onset, there was this situation that one of the judges who was based in Uganda could not attend. Now, it became a question to us whether she could take part in the hearings of the Court of Appeal. Rule 6 of our Court of Appeal rules stated, the court shall sit at any place in Seychelles as the president. President means the president of the Court of Appeal may direct. Now, was the court sitting in Seychelles with two judges here, the litigants here, their lawyers here, and the third judge on the panel sitting in a far-off country? This was a problem we had to grapple with. But of course, that's where we went for a video conference hearing or a Zoom hearing. And therefore, for your information, we amended the rules, and by subsidiary legislation 158 to 2020, whereby we provided that in the event of any inability of the president or any judge of the Court of Appeal to be present in Seychelles to constitute the court due to unavoidable circumstances arising as a result of the COVID-19 pandemic, the sitting of the court shall be by virtual hearing by any method as the president may decide and direct. So we, of course, restricted ourselves to the COVID-19 pandemic. Unfortunately, we had not considered the issue that was raised just now by Justice Renaud. Maybe we were yet at the early stages of trying to grapple and understand the problem. Now, so we confined ourselves to that. Of course, this is a rule that could be looked into and expanded in the future. Now, the question then is it a fair hearing? Leave aside a hearing in Seychelles. Is it a fair hearing? You see, when you say fair hearing may be, there's a subjective element to it and an objective element to it. Fair from the point of view of the litigant, maybe an accused person who is appealing against his conviction for murder. So does he feel, you see, having a judge in another country, and with the present technology, is he getting a fair hearing? Because I can honestly tell you that sitting here and seeing the justice of appeal from another country with the interruptions to the Zoom hearing, it's sometimes difficult for us even to know whether the proceedings are being properly followed by the lawyers and the accused. And the accused feels, yes, my case is being argued by the lawyers. The judge is considering everything. Then, of course, there is the question of, I said, the objectives in an objective sense. Obviously, we cannot merely look at it from the point of view of the litigant. We have to look at it from a public sense, in the sense we have to clear the backlog, we have to dispose of the cases. So that is one of the issues that comes up. And then, of course, as I said, one of the speakers did realize, all hearings so far, the Court of Appeal hearings, we had it only in our conference room, either the conference room of the Chief Justice or in the conference room of the Court of Appeal. Only a limited number of people could come in there. That is the two lawyers representing the litigants themselves, and then the two judges and the other judge sitting the other part of the world. The public cannot come in there. You see, as one of the questioners did raise the point, is there transparency? Does the litigant feel that he's having an impartial hearing before the courts? So that's another matter that has been bothering us, despite the fact that we have decided to go along with it.
The Constitution itself, in Article 19.8, if my memory serves me well, 19.8, makes it law that the public shall have access to court proceedings. Now, the raison d'etre for this is not explained, but we can all discern that it must be associated with ensuring that justice is done, transparency in the process, and that everyone is acting properly and correctly. And I've been involved in a few of these virtual hearings, and as the President of the Court of Appeal has stated, this is one of my concerns as well. How do we ensure that the public has access to court proceedings. But even let's say you use a larger room with a larger setting, how will the public know where where a particular hearing is taking place? Let's say there's a case X versus Y, it's going to be heard virtually. How will Mr. John from Ladig, for example, who let's say wants to follow that case, how is he going to know where or how can he follow that case? Yes, we can go more virtual, but we have to make sure that we've dotted all the I's and crossed all the T's to make sure that we're adhering to the law in our constitution.
Mr. Sabino has hit a very fundamental aspect of the right to fair hearing, which is to have your hearing in public. It's a fundamental right to access to justice. Now, sometimes our courtroom does not have the technologies that allows for such kind of hearing to take place. Therefore, we go in a smaller room, which is the virtual hearing room, mostly for part of the proceedings. But in that room, the public doesn't have access. In that room, a member cannot open a door, a member of the public, and walk in and say, well, I've got a right to attend to these proceedings, because it should be public. And this one is quite sensitive. We need to look into it. If need be, we move the process in an open court so that the trial, the civil matter proceeds in a place, be it virtually, but where the public has access. Secondly, and even more fundamental, is what if the public goes on further and says, well, the hearing is not being done here. Part of it is being done here. Part of it is in South Africa. Because you are here. The person testifying is abroad. I need to be able to experience the whole hearing. And given that part of it is abroad, the witness is not in this jurisdiction, that's also, if he wants to push his argument further, it's not it's denial of a right to fair hearing, because I'm partly hearing what is happening. The other person is virtual. He's not within the proceedings. So that's another one of our challenges. And sometimes it might have to require constitutional intervention. Because whatever we do in a rule or in a law to try to make this happen, if there are strong constitutional provision that stands in the way, then maybe we even need to revisit certain articles to allow access to justice to prevail in this present-day environment.
You know, in the Constitution, I picked up word hearing, and then I realized, are we talking about seeing? Public seeing or public hearing? This is the only thing I've been thinking about. A blind man can hear. Do we need to see? If there's amendment needed to be done to the Constitution, we have to. I don't think there's any way, any time we're going back from technology. We have to go forward.
I'm wondering whether we are challenged often by the Court of Public Opinion. Recently I had a meeting with the Seychelles Human Rights Commission, and I think that meeting came about because of some information that said that we were deficient in certain management of our facility. We were not permitting people to access the court system. We were denying their right to a fair hearing. Again, we cannot do that. We are presented with a document to say produce. We produce. How we produce is something else. I think we need to. The question goes back to getting ready. The Constitution is a living, breathing document, and it can change with the times.
Maybe you could each tell us what you envision about way forward and what you see in dealing with virtual hearings and in the context of the constitutional rights that we're speaking about.
As Chief Justice indicated earlier, if you're going to have virtual hearings, it's very important to try and ensure that a defendant will have an opportunity to speak to his or her counsel during the course of the proceedings and communicate with them on an ongoing basis. If they're in different rooms or different premises, that may be much harder. They may want to comment on a previous witness that's just given evidence and give some important information to their counsel while the witness is giving evidence. And if they're physically separated, that might be difficult. Others have expressed the concern about ensuring that the proceedings are public, not only open to the public, but also to members of the press, to ensure that they are able to follow the proceedings and broadcast the proceedings to the wider public, so that they're able to follow the ongoing legal proceedings that are taking place in this court. There's also the problem of scrutinizing a witness and body language. I don't know how much of communication takes place as a result of our body language rather than just the words that we speak. But obviously that's much harder when you're dealing with virtual proceedings. It's not insurmountable, but it's a harder process to discern whether someone may or may not be telling the truth if you're viewing them virtually rather than in person. And then finally there's the issue of judicial control of the proceedings. I mean, a judge, when everyone is physically present in the courtroom, has the ability to control and see everything that's going on in the courtroom. If people are in different rooms or in different premises, it potentially poses difficulties and problems for the judge to be able to control them and ensure that the solemnity of the proceedings are safeguarded and preserved. I don't think any of those problems are insurmountable, and I think there are solutions to all of them, but there are certainly things that one needs to bear in mind when embracing the new technology that is now available to us to ensure that we have speedier proceedings, notwithstanding the challenges that are presented by pandemics such as COVID-19.
There's no way we can go back. We have to change the constitution, change the law, change the procedure. New technologies are happening, are coming. Even if, for example, I'm giving the example of person Mladig, from the Human Rights Commission, I'm thinking of. That fellow will just go to the center somewhere, I don't know where, the court will be established there. You walk in there, there's somebody there, the process goes on, and then that person goes home. Even in Mahe also the same thing. Police stations are not only in Victoria. All over the place people are arrested. But these are the thinking that we have to start now thinking about this.
I don't think the capacity of the state, of the country, should be hindering us or standing in the way of us moving forward. I know that Seychelles has a constraint when it comes to bandwidth and the capacity to deliver very fast internet system, and this will affect there'll be outages in the system, but obviously the system will advance, it will progress, and by the time that it moves on, we will be there. As to treatment of recalcitrant witnesses, defaulters, etc., we should be empowered. The law has to allow us to treat those persons who fails to appear in a virtual hearing in the same way that we are dealing with those people that fail to obey to our summons or who becomes difficult witnesses. We should be able to extrapolate existing procedures and put it in the virtual system procedure.
In a nutshell, I think there's obviously, from everything that everyone has said already, a desire and to some extent a need to embrace technology and to move forward with the new opportunity that's presented by virtual hearings. But with that, to consider not only the advantages, but try and anticipate what the disadvantages might be and try and address some of those disadvantages when going forward. So previously, as we've touched on, for example, the difficulty of defendants, if they're not in the same room or the same physical space as their counsel, to try and facilitate ways for them to be able to communicate with them during the course of the proceedings. I know in other jurisdictions where they have defendants or appellants who are not physically present at court, but they have a telephone booth where they can have a video conference with their client and counsel prior to the hearing and at breaks during the course of the proceedings, so that the defendant or appellant can update their counsel as the proceedings are proceeding if they're not in the same place together. With regards to ensuring that proceedings are public, of course, the virtual proceedings can be made accessible on the internet at the same time, which, if anything, will give greater possibility for the public to be able to engage in virtual proceedings than they can with regards to coming into a physical courtroom, because of course it's much easier to sit at home and turn on your computer than it is to physically have to come to court and step into the public gallery at court. But then, does that create any potential risks and problems? On the one hand, potentially it does. I mean, we all know the dangers of social media. It doesn't stretch the imagination to think what members of the public might do if they could watch legal proceedings in their own home on computer. They could quite easily just record the proceedings and then put them on social media, which isn't necessarily a good thing, and certainly wouldn't be allowed if they were physically present in the courtroom. So that again is something that would need to be considered and addressed. It may be that you could have a separate section of the courtroom where everyone could be suitably socially distanced and watching on a big screen in that room, rather than allowing everyone to watch it on their computer screen or access it via the internet. With regards to assessing a witness's credibility, of course it's always preferable to be able to see a witness in the courtroom, to be able to observe their body language. But I'm not sure necessarily, and certainly it's not my experience whenever I've done virtual hearings, that you're necessarily disadvantaged by not being in the same physical room as the witness. Sometimes seeing a witness's face up on a big screen in a courtroom, you can actually read a lot more into the proceedings and detect a lot more from someone's face, which is much, where there's much greater focus on it, and they're under much greater scrutiny just from their visual appearance than if they're in a courtroom maybe 20, 30 meters away from you. Particularly if in court it means that a witness has to be masked, where you can't actually see the full visage of the witness and the face of the witness when they're giving evidence. So all that to say, there are real opportunities presented by virtual proceedings. I mean, what's the expression? Justice delayed is justice denied, and virtual proceedings in many ways provide a solution to that, in terms of at least being able to speed up proceedings and ensure that the judicial system is able to continue operating in the way that it must do, even in times of emergency such as a global pandemic. So in a nutshell, they should be embraced, but very real consideration needs to be given, I think, to the challenges posed by them as well.
I'd just like to add that the argument of allowing the accused to face his accusers, so we need to go to the stakeholders and find out what is it that we really want, and that is fair, that is using existing technology, and then must the law be amended to achieve what we want? And then the bigger question, must the Constitution be amended? And that would even call for that might even call for the need for a referendum. So let's assess as well what we want, and from there we can move forward. That's what I want to add.
I cannot take full credit for this idea, but this is the proposal of Mr. George. Is it perhaps time that we consider moving to a more continental approach, which means we file extensive statements of agreed facts, which reduces the amount of time that we need to spend in court as lawyers, judges, and clients alike? We front load the work, essentially, so that the amount of time we spend in court is limited to cross-examinations, and that's it, essentially. Maybe it's time that we start thinking along those lines, especially when it comes to civil cases. I think this would be perfect.
Good things come from these kind of forums. Every year, on this day, following our deliberation, resolutions are taken and final communiques are done. And for this one, I think all the stakeholders are around this table. Everybody that should be involved in progressing this matter, this agenda further, is here. So I suggest that each of us, we go back to our respective organizations and workplaces, and we give an input on how to forward this matter, how to progress this matter, namely virtual hearings and the right to fair hearing, and also the greater picture, which Ms. Kelly has referred to, which is e-filing and e-court system. which is also something that can be looked into. So we, judiciary, we're ready to receive all the inputs from the stakeholders so that we can put forward a paper which will form the basis of the changes that needs to be made. As far as the practicalities is concerned, I note that the issue of communicating instantaneously between counsel and accused who are not in the same premises in the virtual hearing system, which is a constraint to right to counsel, which I started off with. This can be remedied. I've seen in other jurisdictions that counsel has a microphone, small microphone, which is fixed to his client there, in the other room, in the other place, where they can communicate via voce, live to each other. You don't need to go into a booth, so that instruction is received instantaneously, and there is two-way communication between the two parties as and when the trial or the hearing proceeds. When it comes to access to by public to a hearing, I think virtual hearing has to be done in a courtroom where public has access subject to restriction which the law imposes as part of the court management. Now, when it comes to other parties that have no access to the system, they do not have a laptop, they have no smartphones, but they want to access the court through the system, I think the duty calls for the court to have these systems regionally, where annexed with our courtroom, there's a virtual hearing room. Just as we do in cases of vulnerable witnesses where the witness is in another room, that person goes there and he or she is under the supervision of a court staff, and they communicate to the court. So we, again, access to justice, and we are there to aid that access by making facilities that are conducive towards the system available. The only constraint that I see, which will be difficult to overcome, is that of credibility, demeanor of witnesses. But this we will leave it to the trial judge, who will have to take note virtually of the demeanor of witnesses or accused on the other side of the screen.
As far as the Human Rights Commission is concerned, we watch the fundamental rights to fair hearing. That is our job. But the other ramification here and there, most of you have to adjust it over time. That is understood. But we will, yes, we will put our contribution, objective contribution, based on international standards as defined either by International Human Rights Commission, United Nations, and Commonwealth. We pick all these things and we measure whether we are meeting it. We will do that, yes.
Given that we're going to move into, and it seems, a whole new way of doing things, it will be important especially to have key measures as to how to educate the public, because not just the public, but the users of the system as well. We've seen in the past when there's been changes that happened, it takes time for people to understand how the procedures work. And like my learned friend stated, Kelly, that she'd like to see a system, an e-court system. That is going to take time. It's going to take training, and that is and we need to build the infrastructure in Seychelles, and it's all going. And so we have to accept that it's not something that we can change overnight, but it's we have to have clear goals and clear consultations with everybody involved.
As a department or prison service, we would not want to be cut short and not be ready for these changes that are happening. So reading the tea leaves, we can be certain that this is the way forward, as the CJ and all the other panelists have been talking about, and that we should be ready for these changes and embrace technology, not be afraid of it. So therefore, in our plannings for our future prison facility, like as an example, our high security prison at the Bon Espoir that we are planning on for a different category of inmate, where it may not be possible all the time to transport these people back and forth, is to have these hearing rooms, which are sanctioned, and the technology to support. Recently, the registrar sent me an email, said that continue to embrace virtual appearances, which we had just moved our equipment from Montagne-Posé to the remand center. We only have one. So it's for us now to plan properly and budget it accordingly and to have these extra facilities in place so we can meet the requirement of what the court is asking us to do, and able to, for our client or the inmate, to be able to access accordingly.
And of course, the next call to action would be to act on this. It was a very powerful and useful discussion, and the best thing would be to have it all consolidated, come together as something that we can work on, and this would be the perfect panel to carry it forward.
C'est un débat que Zidisyer a organisé à l'occasion de la Lazournen Constitution pour regarder comment la technologie devrait être plus grand service en cours qui fait que les gens n'ont pas besoin de venir physiquement en cours, soit pour écouter d'autres cas ou bien pour donner l'évidence. Merci pour suivre.